We had a thing called Boogie Down in the 80s where inmates would look for any opportunity they could to get out of their case or get a lesser deal on their case. And so this lead to the jailhouse snitch. A jailhouse snitch would try to get a better deal for himself, so he would look for something to tell. Well, the two guys who claimed that I bragged to them in just 10 short minutes, 10 minutes of meeting total strangers in the city jail. You know, when you get arrested, they put you in the city jail in this big old holdover. They claim in 10 short minutes of meeting them, I bragged about a murder. Bearing in mind, I wasn't even charged with murder. I was there for credit card abuse. They said I bragged about a murder. So the guy who recanted, he admitted that they paid him. They dropped his case. He had an aggravated robbery case. They dropped it. And then he lied. Well, he also called Miss Tammy Lane Campbell and confessed that he lied. He also contacted the sergeant of the Houston Police Department, Sergeant Rodriguez, and told him he lied. So it's a blessing that he had a change of heart, but the damage was done, and his lie and the other guy's lie led me here. So what he said was the other guy lied as well because we was right there together. If I didn't hear it, he didn't hear it. So they contacted the other guy, and all of a sudden he has selective amnesia. He can't remember anything about the case. He remembered testifying, but he can't remember what he said. So he has selective amnesia. So that's what things are with the inmates line. So they use inmates and my own sheet of paper to get me here. Mm-hmm. That's the only evidence they have on me. That's pretty much the gist of my case and what led to this struggle.
And I want to go back again, if you don't mind. So you're being charged with credit card abuse. You had never been in trouble with the law. You were at the Galleria because you were working at the Galleria.
Absolutely.
So I'm just trying to imagine, how did you feel sitting in jail with that charge, even before they came with this other charge?
Well, because Richardson came correct from the beginning. From the beginning, he explained everything. At Florsham, we had a whopping deal of 52% off. And there was some wingtip shoes that I was going to get anyway. So we seen the shoes at Lord & Taylor, and he said, look, I just buy them, and you just pay me back. You know, when you cash your check, just pay me back. I said, okay, I'll do that. So that's how I ended up with the shoes. But he told him everything. It had nothing to do with the credit card abuse. I found these credit cards in a parking lot at a park, McGregor Park. He told everything. So I wasn't really worried about them convicting me on credit card abuse. Plus, all the store tellers would tell who was abusing credit cards. So I wasn't really worried about that. But when it escalated from credit card abuse to capital murder, that got my attention. It got my attention.
Yeah.
So I had an attorney, a fellow fat brother named Jack Terry. His thing was, you shouldn't really have to worry about this conviction because they can't really prove anything. So they appointed me a guy named Tom Robeson. Tom Robeson was a former prosecutor for 13 years. Mm-hmm. And so he said, look, man, I've tried cases like this before, prosecuted cases like this. This is not going to convict you. Speaking about my sheet of paper. But what I didn't know until I learned the law, that when it comes to fingerprint evidence, one of the things they have to prove to make it valid is to what extent was the item accessible to you prior to the offense. If it's a readily movable object, such as the sheet of paper, and you have prior access to it, like I did with my own finger, my own notes, then the courts rule this is invalid. So I didn't know this, and I studied the law and found out that the key to fingerprint evidence is to what extent was this item accessible to you prior to the offense. So the state burden is to prove you didn't have prior accessibility to this, thus you imprinted this at the time of the offense. For instance, if my fingerprint would have been found on the victim's car anywhere,
Mm-hmm.
there's nothing I can say.
Right.
But being found on my own sheet of paper, I got prior access to this. These are my notes.
Yeah.
And so as I asked Mr. Randy Wallace on Fox News, how are you going to carry a whole sheet of paper with one finger? If you saw the broadcast, I held my finger up like this. Said, how can I carry a whole sheet, at least a thumbprint or something else other than just my index finger?
Oh, no thumbprint was found.
Yeah, just my single right index fingerprint. That's it. That's what he said links me to the offense. See, at the time in the 80s, the golden standard of forensics was fingerprint evidence. Now, of course, it's DNA.
Mm-hmm.
But in the 80s, if they said your fingerprint was there, that's like 100% evidence against you.
But speaking to the DNA, you requested a DNA testing of evidence. Is that
okay?
correct?
What happened was the Houston Conviction Integrity Unit,
Mm-hmm.
a guy named Mr. Baldwin Chin, he was over it at the time. He looked into my case. Houston was just starting their charter on the CIUs. It started in Dallas with Mr. Craig Watkins. He even freed about 35 people. So Houston picked it up, and now it's everywhere. But the Mr. Chin had his own suspicion about this sheet of paper. So what he said was, why don't you agree to DNA? Because the DA said the victim was in a struggle with his assailant.
Mm-hmm.
Struggled with him and was forced into his car and ultimately got shot. Would you agree to DNA? Because if you're in a struggle with someone, generally my DNA would be on your fingernails. If you grab my arm, and it's such a small fragment that they need, and they blow it up, and they can nail you through fingernails. So he asked me if you would agree to the DNA, then I'm gonna do all in my power to exonerate you if the DNA come back excluding you. So okay, why not? Let's do this. So we did the DNA testing. It came back excluding me, but he didn't keep his word. He didn't try to move to exonerate me. I guess now, what happened? We thought that it would be his DNA.
Who is the person that you say didn't keep their word?
Mr. Baldwin Chin. He was over the Conviction Integrity Unit in Houston back in 2012.
Okay.
He was the first president, if you will, over the Houston charter of the CIU.
Mm-hmm.
So he and my lawyer filed a joint motion for DNA testing, which the Judge Mabel O'Kill, signed off on it. And so when the results came back, excluding me, the analyst said, but look, this DNA can definitely be linked to a source. So send me any known suspect, any blood or saliva, or anything I can use to link someone to this source because it can be linked. But it wasn't me. So what they did was, okay, we're going to see if we can make sure the victim is excluded. So they took morgue evidence and everything, and it was just too degraded to get a profile. So they went and got the victim's son and tried to do what they call a familiar DNA testing, that maybe through his roots, through his DNA, through his family, we can link whether or not the victim should be excluded. They got the son, did the DNA testing. Well, the DNA expert testified the victim also is to be excluded. So it leaves the third party, a third person, who may be the likely assailant. And so this is what things are right now. And this is what the Court of Criminal Appeals has to decide. To what extent is the DNA exculpatory or not?
Mm-hmm.
And so that's where the DNA come in at. They're the ones who requested the DNA. The CIU did. And I just agreed to it. So they came here, swabbed me and everything. And the DNA, when they excluded me, he just did not keep his word. Ultimately, he got replaced. But had he kept his word, I would have sped up my process.
Yeah. What is your main argument for why your case should either be retried or that you be released?
Well, my main argument, of course, is actually innocence. I think the casual observation, I would encourage anyone to investigate, to do your homework. Don't take my word. Look at the evidence and determine whether or not there is enough evidence to convict.
Mm-hmm.
And when you examine that evidence, which is my sheet of paper, that's all they have, and the inmates saying, I told them I bragged about this. That's all they have. When you examine this evidence, you would agree a wrong was done. As far as I'm concerned, Houston police officers and working with the DA, they committed a criminal act against me by going into my property and taking my sheet of paper and claiming they found it at the scene. It was never at the scene. Never.
Mm-hmm.
And they know this. And when you look at the itemized listing and the pictures and look at all this evidence, you'll see it was never there. But this is what they used to put me at the scene, was my own sheet of paper. Namely saying that my single fingerprint, my single right fingerprint was on my sheet of paper. And when you're writing, it's possible I could have left a fingerprint because this is my sheet of paper.
Mm-hmm.
But I don't believe it was a fingerprint. I think they just used that because at the time, fingerprint evidence was such a golden standard of forensics that if they could link you through fingerprints, you pretty much, you were there. You done it.
Mm-hmm.
Never mind that they found several fingerprints on the car. Several. Not mine.
Mm-hmm.
They found several fingerprints on the car, but none of them were mine because I wasn't there.
Right.
But this is what they use. So that's pretty much the gist. So the main thing that I'm pointing out is the evidence that led to my conviction is all fabricated. And if anyone would give a casual scrutiny of my case, they would agree that none of this makes sense, especially when you can't corroborate through picture evidence and through itemized listing that the sheet of paper was there on the date of the offense.
Mm-hmm.
It poofed up 90 days later. And the argument that my fingerprint was on that paper was used against me as so-called fingerprint evidence. But now DNA reigns supreme. So if you DNA exempt, it's supposed to have precedence over fingerprint.
Okay.
And so this is for the court to determine. They ask for all the records, they ask for all the exhibits, and they can see it for themselves. I've been arguing this for a long time that you see the paper was never found at the scene, came out of my property. I couldn't prove it until my lawyer presented to me the offense report.
Mm-hmm.
When I finally got the offense report, I think it was like 2013.
And you had already been in jail for how many years at 2013?
In 13, I think it might have been at that time, maybe 28 years, something to that effect. But right now I'm in 38.
38.
Yeah. 38 years of wrongful imprisonment behind this. And so the argument that should have been presented, my trial lawyer, Isaac Hennessy, I mean, I guess